Hi, thanks for using My Court Coach. I'm Jalen, and I will be your instructor as we navigate the form DV 105, Request for Child Custody and Visitation Orders. Now, this form is a mandatory form when you are requesting a domestic violence restraining order and you're requesting a change in your current child custody and visitation orders, or you want child custody and visitation orders because you don't have any in place right now. So make sure that this form is in fact attached for all of your children that you have in common with the other party. You don't just list all of the kids because you might have children that are not in common with the other party. You only list the ones that you have in common with the other party because they can only exercise visitation with the children in common by law. So in order to fill this out, you'd write in your name, whether you're mom, the dad, or the other, and the other is somebody who does have legal authority over the child. So whether they're a guardian of the child and they are the person that's filling this out, they're filling out the request for the domestic violence restraining order, then you would go ahead and type in other, then they would be the ones to fill this out. And then the other parent's name, whether they're the mom, dad, or other, and you would include that as well. So if this is mom against the legal guardian, you would go ahead and check off mom, other, and then type in the name and guardian. So child custody, you would check off this box if you wanted to change or have legal or physical custody. Again, legal means making decisions about the child's health, education, and overall welfare. Physical custody is who the child lives with primarily. So you're going to include all of the children's names and their date of birth. And again, it's the children that you have in common with the other party. And then if you have a current court order, then you would ask the court to change it. And if your case number is different than what is being filed with your restraining order, you would go ahead and include it if you do have that case number, what county it's in, and then what is the court order and why you want it changed. And so if you need to attach a sheet of paper and write in, DV 105, you can go ahead and do that and then just include this form right here, the MC025, and you can just say, attachment to DV 105, and you could even title this whatever it is that you want to title, change current court order, and then type in what the changes. So what the current order is, and then what you want to, or why you want to change it. And the why is going to be related to the domestic violence restraining order. So the child's address. So the child's address is going to be where they've been living for the last 5 years. And so if they've moved around in those 5 years, then you must identify all of the addresses. Now, when we say address, though, it only really asks for city and state. So if it's within, San Diego County and they've only had San Diego addresses, it's not like El Cajon or La Mesa or anything like that, then you should just keep it as San Diego, California, and then who the child lives with currently. I like to write from the time that the abuse happened. I would just say that the abuse happened again, like February 2nd, 2018. I would write, 2/2/19 until the present. The children have been living with me, and whether I'm the mom or the dad. And then from whatever date for the last 5 years to February 1st of 2019, then I would say that they lived with both me and the other party. And the reason why I do it that way is because now I'm doing what I think is best to protect, the kids, and I want them to live with me full time, and they've started to live with me full time since the incident took place. I think that just looks better for you if you are the one that has primary custody of your children. And if your children were involved in domestic violence, it's always good to make sure that you are putting your kids first, and the courts like to see that, especially in a domestic violence situation. So don't be fearful of that, because you are doing what's best for them by protecting them from the aggressor. So next thing is other addresses. So if you have other children that were not identified, here or here, then if you have children's addresses, so this is how you would complete it. And so if there's more addresses for the last 5 years, again, you would just go here and you would change this out and just write child's address. So let's say you had more than 3 kids, or at least 3 kids, and those kids have lived at different addresses but not together, then you would want to go ahead and check off this box, and check off the second box, and you would write in the child's name, like child A, and then their 5 years of addresses, and you would include that in there. And then child B, same thing. You would do that for every child if it's in fact different. But if it is the same, and there are, if it is the same, then you would just go ahead and include them in this box right here. Other custody case. So if you're filing for a restraining order and you also have a paternity action that you have filed, or a divorce action that you filed, or even a child support case that you've filed, you would want to go ahead and list that here. And so you would list, okay, yes, they were involved in some other case, name of each child in the other custody case. So you'd hopefully be naming the same children that you're naming on this form. And then you would identify whether it's another child support case, a divorce case, a juvenile case, guardianship case, or some other case. And then whether you were a party or a witness, or what was your relationship to that case. So if you were a respondent in the child support case, you would say that you were a party to the case. If you were a petitioner to your parentage case, you would say that you're a party. And then you type in the court name, address, county, state, the date of the court order that went into effect about your child custody and visitation, and then of course the case number if you do have it. And sometimes that, like, if you are filing this restraining order under your divorce case number, then you would still fill this out and check off the box divorce, and say that you're a party to this case and all of that. And the only reason why we would fill it out that way is because this is a brand new action that you're essentially attaching to an existing action. So it's important for you to complete it that way, but you don't have to. It's definitely optional. There's no wrong or right way to do it, but I like to differentiate the cases in that regard and say, yes, there is a different custody case under the same case number, but I want the court to be aware of that. Okay, and then is there other people that are claiming to have custody or visitation rights? So if part of this is, your grandmother wants some visitation rights and you're saying no, and this is just escalated to a point where there is some domestic violence now, you could absolutely list them. You could list her name and her address, and she's claiming to have custody rights or visitation rights or something along those lines. And that's just one example of how somebody can be claiming to have custody or visitation rights. Or maybe even a step parent, they are claiming to have custody rights. Maybe they filed for something in your parentage case and they're asking for custody rights. So if they're claiming anything, even doesn't mean that they have it, it just means that they're claiming it, they're requesting it. you would go ahead and include that information here. But if they do in fact have it, then you would check off this box, has custody. So visitation. So this is very important because sometimes parents complete this in a way where it's confusing. Like if your description of your abuse is mom was choking the children and dragging them by their hair from the living room to the dining room, and then you say, oh, well, yeah, I want her to have the following visitation until the hearing and after the hearing, weekends, every other night, and weekdays, twice a week. And that's puzzling for the court, and I'm sure that the judge is not going to grant that request because you're supposed to be protecting the children, and you're doing that by filing the restraining order. And if there's anything along those lines in your restraining order packet, then the court's not going to allow for visitation, even if you request it. They may not even allow for supervised visitation, even if you request it, especially if it's to that degree, because that's such a traumatic experience for a child, and they would not think it's in the best interest of the child to have even supervised visits under those circumstances. So they would most likely say no visitation until the hearing and no visitation until after the hearing, or the court would actually just say until the hearing, no visitation, even if you checked off something else. So it's really going to depend on your description of the abuse and the context in which your children were abused by the aggressor. And if you did want to include some visitation because there wasn't any like physical violence, and let's say you and your spouse were in the house and the children were in a different room, and they didn't really see anything, but they may have been aware of it. But you know that the children are just very close to the abuser. They've never hurt them. They're actually a great parent. They're just horrible to you. And so maybe you do want them to still continue that relationship, because if you didn't and the children were stripped away from the other parent, then your children would potentially backlash at you, and it might cause greater damage, and maybe they would actually need some therapy, and they should be going through some sort of therapy if you are at this position where you are requesting child custody and visitation. So you can have some other visitation schedule if you don't like this setup. You can ask for a different visitation schedule, and again, you could use this DV 105 to include that on there. And then responsibility for transportation. So who's going to pick up and drop off the children to and from the visits, especially if you have a restraining order protecting you. You don't want to be the one to drop them off, or you can be the one to drop them off because there is an exception to your restraining order that you've asked for, that anything relating to your children, you want to at least have contact with the other party about that. So if that's the case, then you would complete this. And then if you only want the other parent to do all the exchanges and you'd provide an address for that exchange, then you can request that as well. If you have any other arrangement that you would want for the exchange, then you would go ahead and include that in this form as well. Just, type in exchanges, and the court will understand what arrangement you're asking for exchanges. Or you can write responsibility for transportation. Essentially, it's the same thing. So supervised visitation. So if you have a visitation schedule here and you want that schedule to be supervised, then you would, in fact, check off this box and then list whether it's a professional supervisor or a non-professional. So a professional supervisor is somebody that you are paying, or maybe you have a friend that is a professional supervisor, but they're not going to charge you anything. I would still include them as a professional supervisor. And then a non-professional supervisor is somebody who's not professional. So like a mutual friend or a family member, those would be considered non-professional supervisors, or somebody else like, a coworker or something like that, that you'd want. So I would never have the abused person be the supervisor. For whatever reason, individuals think that, well, I still got to protect my kids. I need to be around them. And, I'm just going to suck it up and supervise the visitation between my ex and the children. And that's not okay. The reason being that's not okay. It's already a hostile situation. And then you're going to think about, how does that look for you in court when you're telling the court, I'm afraid of the other person, I'm in fear of my safety and what they may or may not do, I want to protect my kids because I don't know what she or he might do to them. And then you're also saying, but I want to supervise the visitations because I do want them to have a relationship, but I want to be there. It's kind of looks a little disingenuous and inconsistent with what you are requesting. So what you're requesting is that you want to be protected from this person at all times. And so you're not going to supervise the visits. If the other parent wants those visitations, they're going to have to figure out how to set those visitations and how to schedule them. And hopefully there will be a clear order as to what the visitation schedule is like, and they wouldn't necessarily even need to confirm with you whether they're exercising the visitation schedule or not. It would just take place because it is a court order now, and whether it's by a professional, like Hannah's House, for example, they provide supervised visitations, then you can go ahead and include that, include them here and their address and phone number. And then you could also write, who's going to pay for supervised visitations, because those definitely can get costly. But some places like Hannah's House, they can do things based off of a scale. So depending on the income of the party, and they might reduce it. But you can say 100% to mom because, she's the one that put herself in that situation. So she should just pay for the supervised visits. Or you can do 50-50 because the other parent wouldn't be able to exercise visitation unless you're able to contribute to professional supervised visitation. And you think it's in the children's best interest to see the other parent to see the kids. And you want to make sure that happens. So you're contributing at least, 50%. So travel with the children, you're going to ask the court that it orders that you guys have written permission from the other parent or a court order to travel outside of state of California, county of wherever county you're at, or other places that you want to list. So this is also important if you do not want the children traveling anywhere. Child abduction risk. So if you believe that the children are at risk for child abduction, then you would go ahead and fill out the DV 108. So if you make a temporary custody order, it says the parent receiving custody must not take the children or the child out of California without a noticed hearing. So it means even though you are asking for sole custody, it does not mean that you're able to just travel with the children for the next 3 weeks outside of California or move them outside of California either. I hope that you have found this helpful, and good luck.